Testing. Testing. You can hear me? Okay.
Yes. Good morning. How's everybody doing? We're so grateful and appreciative for you coming out today for this wonderful presentation. Attorney Duckett is going to talk to us about estate planning, something we definitely need, something we put off, something we wait too late to address. She's going to concentrate on wills and trust. So sit back, take some notes, and I'm sure you'll have a lot of questions, but it's wonderful and vital information for us. I'm going to share a little bit about Attorney Duckett. She has been estate planning. She is the elder in her law firm, is licensed to practice, it got kind of loud there, in the states of Georgia, Maryland, and the District of Columbia. Her interest in the debt and dedication is to practice in these areas. It stems from her relationship and experiences with her father, who died from Alzheimer's disease, and her sister and her nephew, who both have Down syndrome. She has firsthand experience, knowledge, and understanding about the challenges individuals and their families face caring for aging or disabled family members. Dion's goal is to help her clients gain peace of mind by providing quality legal services and to address specific needs. These are areas that are underserved in a lot of situations, so we are so appreciative of her coming to share her time and her expertise. So let's give her a wonderful hand of applause, and she will get started. Thank you.
Thank you. And I thank Zion Hill for inviting me. I think this is my 5th year coming, so I'm always happy to come. I'm a member at Ben Hill United Methodist Church, and I think we're going to try to copy your program. We're having technical difficulties with my presentation being up, and that's my fault because I didn't send it in advance. But we're going to get started. We're talking about protecting your lifestyle, your loved ones, and your legacy. And basically it's estate planning 101. So I want to start by saying this presentation is for educational purposes only. Nothing should be construed as legal advice. So if you have a particular concern, you should seek your professional advisor. Also with questions, we'll take questions at the end, but if your question is to a particular situation, then that's something that takes a consultation. I can't answer those types of questions, just general education type questions. So I like to start by asking, what is your estate? Anybody? I heard somebody say assets. Anything else? Okay. So it's basically everything you own. So that can include your real estate, that can include your personal property, which are things you can touch, like furniture, clothes, jewelry, all that stuff. And so estate planning, it involves your property, yourself, and your family members and your loved ones. It also involves your legacy and your values. So, anybody can tell me why you should plan? Yes, ma'am. The answer was to keep it to in the family. Anything else? Keep families from arguing about what's mine and what's yours. Okay, so yes, peace of mind. Yes, ma'am. To keep it from going into probate. And so you can plan and it'll go into probate. And so, but, yes, sir? Oh, no, he's still working on. So basically, a lot of times people, when they think about planning, they think about what happens to my stuff when I die. But you also have to think about what happens if you live. What happens if you become disabled? Who's going to take care of the things that you take care of? Who's going to take care of you? So it also involves that type of planning, making sure that things are taken care of the way you want them to be taken care of, you know, if something happens. Not yet. It's working now? Okay. All right. So what happens if you don't plan? Okay, I heard someone say it may go to the estate. Yeah, probate judge will make a decision. So how many people in here have an estate plan? You have an estate plan? Okay. All right, that's good. So the truth of the matter is everybody in this room has an estate plan. If you have not done your planning, the state has a plan for you. Okay? So if you want things to be taken care of the way you want them taken care of, you've got to do your plan. If you want things distributed the way you want them distributed, you've got to do your plan. Because if you die what we call intestate, that's without a will or a plan, then everything is going to go according to the law. The statute says who your heirs are and who will receive. So, next question is, who should do their planning? I see somebody pointing to themselves. I hear everybody. Okay, and so a lot of people think that you don't have to plan until you get older. And you have to do it while you have capacity. Otherwise, it could be too late to do your own planning. But anyone who's 18 years or older should have some type of plan. Because if you have kids going to college, you know, they've turned 18, what happens if they're in an accident? Your mom, your dad, you can't make decisions for them anymore. And so we had a family member, friend, 20-something years old, new job, new apartment, in a car accident head-on with a drunk driver. And he was in a coma. He had new apartment, new cable bill, all that stuff. He was going to have to go home and do rehab. And when they were trying to stop the bleeding, cut off the bills, Comcast said, "Where's your power of attorney?" So you need to have a plan in place. If you don't have a plan in place, then the court has to get involved. Guardianship. Guardianship is the court appointing somebody to manage your care. Conservatorship is the court appointing someone to manage your property. And that can be lengthy sometimes and can be expensive, and it requires ongoing reporting to the court. So anyone 18 years or older, and it's not just about planning for what happens when you die. So the next thing I want to talk about is threats to your estate. So who can tell me what some of the threats to your estate might be? I heard someone say taxes, lawsuit, eminent domain. You said titles? Okay. Yes. And so all of those types of things, but I have a list. So one can be incapacity. So if you become incapacitated, you may have to rely on government assistance. Depending on whether you've worked and paid into the system, you know, disability, you've got Medicare and Social Security disability income, that's based on your FICA and paying into the system. And then you've got Medicaid, if you haven't done that, and that's means tested. You usually can't have more than a certain amount of income. You can't have more than a certain amount of assets. If you have to go into a nursing home, who knows how much nursing homes cost in Georgia? Yeah, so the average cost of nursing home care in Georgia is $10,000 a month. Okay, so, and we'll get back to that. Another threat to your estate is immature heirs. And I'll talk about each of these. Spousal remarriage, if you die and your spouse gets remarried. Blended family issues, and I think most of us have blended family issues these days. Irresponsible spenders. Substance abuse issues, if you have loved ones who struggle with alcohol or prescription or non-prescription drugs. And then there's also the concern with self-serving caregivers. So there's two basic ways or fundamental documents that go into the estate plan. And the thing that I want to note about the documents, the wills, the trusts, those are tools. Okay, so I have people who call me and say, I want to get a trust or I want to get a will. And when you approach an attorney, you should really go with what your goals, objectives, fears, and concerns, because it's a counseling relationship. And so you may not need a trust, or a will may not be what you need. I heard someone say that the purpose of estate planning was to avoid probate, and it can be, but if you plan with a will has to go through probate. So the definition of probate is to prove the will. So if you plan with a will someone has to file a petition to have the will proven as valid, and then to have the person you've named as executor or personal representative appointed. So in the will, you nominate who you want to wrap up things for you. A will does not become effective until after you die. So while you're alive, it doesn't matter what the will says. It has no control over your property. The will is also where you can name guardians. If you have minor children, or like my sister's 39, she has Down syndrome. So if you have adult disabled children, minor children, that's where you can nominate who you want to take care of the people you take care of and who you want to take care of their property. So the definition of a will is basically a legal document that, like I said, it designates your guardians and conservators for people who are dependent on you. It also designates where your property goes when you die. It's a public document. So when you petition, or when someone petitions to have your will proven as valid, it's recorded in the court. And then anybody can come and look at it. All right, so if you're concerned, anyone can come and pull the records. If you're concerned about privacy, how many people have people calling 10 times a day to buy your house? I had somebody send me a text message asking to buy my post office box. They don't even read the addresses, so they watch the records. They watch the records to see who's filing, and they start. So if you want privacy, then the will may not be the way to go. So I want to talk about probate property. So probate property is property that's titled in your name alone at the time of your death. So if it's probate property, it has to go through probate. All right, so if you die without a will, it's called dying intestate, and then we have intestate estate administration. The difference between estate administration and probate is that with probate, the will says where your property goes. With intestate administration, the law says where your property goes. But once somebody's appointed, they're both, in intestate administration, the person is referred to as the administrator. With probate, they're referred to as the executor. They're both referred to as the personal representative. Make sense? Okay, and then the process is typically the same. On average, when nobody's fighting, it takes about 1.5 years to go through probate. In Fulton County, it might take 3.5. And especially since COVID, they're having a lot of issues with turnover. And so, to talk a little bit about the process, some people say it's like filing a lawsuit against yourself, because when you file to petition the will, notice has to go out to people to give them the opportunity to object. They call it a caveat. They can object to what's in the will, but the only objections they can make is that you didn't have the capacity or the will is not valid. All right, and so then the other thing is notice has to go in the paper for 4 consecutive weeks to debtors and creditors. That's to give creditors an opportunity to file their claims against your estate. And so the purpose of probate is to protect beneficiaries and to protect creditors. and to efficiently administer your estate. Types of property that are not probate property. So we said probate property is property that's titled in your name alone at the time of your death. So property that's titled jointly, joint tenants with rights of survivorship, that would be property that is not probate property. Because if it's joint tenants with rights of survivorship, when one person, one owner, it can be more than two, but when any of the owners dies, then the survivors automatically get it. It doesn't have to go through through probate. And then when you get down to the last person, now it's probate property. So if they haven't planned, it's going to go through probate. Is there an echo? No, okay. I hear an echo. All right, and so another type of probate property is property that has beneficiary designations. So that can include life insurance, retirement accounts. So all they want, the company wants, is your death certificate, and then they'll write the check. And we'll talk about why that can be good or why that can be bad. And then property that has beneficiary designations, payable on death. So sometimes people put payable on death designations on their bank accounts. That's just like a beneficiary designation. So it's going to bypass the probate process. And then, like we said, probate property is property that's titled in your name alone at the time of your death. So if it's owned by a trust is a separate entity. So if it's owned by a trust, it's not owned by you, and that's how a trust avoids probate. Georgia has also, when we talk about jointly owned property, so with real estate, property can be owned jointly in a few different ways. So it can be jointly with tenants with rights of survivorship, and so that means it automatically goes to the survivor. And then the other way is tenants in common. So if it's tenants in common, there's no rights of survivorship. So you may own your property with one other person. When you die, when one person dies, because there was no joint tenants with rights of survivorship, it doesn't automatically go to the other person. So you might own your property with your spouse as tenants in common, and your spouse can leave the property in their will to their mother. So then you end up owning your property with your mother-in-law. So, so how your property is titled. Georgia also has come out with a new deed. The legislature is still working on the laws about it, but a new deed called a transfer on death deed. And so that's where you can basically put a beneficiary designation on a deed. And so you're not transferring it while you're alive. There's lots of rules that have to be met. A lot of times people don't probate until years later, but that transfer on death, everything has to be done within 9 months after the death. So can't miss it. All right, talking about the cost of probate. So with probate, I mentioned that you have to file the petition. So there's court costs. You may have an attorney, so there's attorney's costs. The personal representative, which can be the administrator or the executor, they are entitled to take a commission. And so they can get 2.5% of all the assets that go into the estate and 2.5% of everything that's distributed out. That's the cash. Then they can also get 3% of the value of other property that's not liquidated, so like if a house is transferred. And so basically we're talking about probably about 5% or more of the estate. Now if people are fighting, then the cost can get a lot higher. And the court requires mediation, so hopefully people can work things out, and then we'll go to the next step. And then if you have attorneys, you got attorney's fees on top of that. There's publication fees. I mentioned that you have to put notice to debtors and creditors in the paper for 4 weeks. Sometimes there's publication fees, just putting notice that the will has been filed to be, or the estate, either the will or the estate, someone has petitioned to open the estate. Sometimes inventories and accountings can be required. The will can waive those. Okay, but if they're not waived, then inventories and accountings have to be done every year so that the court is monitoring the process. Let's see. All right, so we're talking about ways to avoid probate. So what we say probate property is property that's titled in your name alone at the time of your death. So one way you can avoid property is by making lifetime gifts. So people do things like add a child's name to their deed, or other types of transfers. So there's a couple of problems that need to be, not necessarily problems, but things that need to be considered. So one would be capital gains. Who's heard of capital gains taxes? Okay. So if you transfer appreciated property, capital gains is the tax on the appreciation. And so I like to use the example of my parents' house, which they bought in '72 for $75,000. And so now it's probably worth $675,000. So if they were to sell that house today, the capital gains tax, before any deductions or exemptions, will be based on their basis is what they paid, the $75,000. And so you subtract the sale price, $675, you subtract $75, you got $600,000. That's where the tax calculation starts, on $600,000. If they gave the house to me today, and then I sold it tomorrow for $675, I would get their basis, which was the $75, same calculation. On the other hand, if they left it to me through their will or through their trust, and I inherited it today, and then sold it tomorrow, I get what's called an adjustment in basis. And so it would be a step up to the fair market value at the date of death, which is $675. So if I sell it tomorrow for $675, then my capital gains calculation is $675 minus $675, 0. Okay? And that's still 10 years from now. If it's worth $1,675,000, it will be based on $1,675,000 minus $675 versus $1,675,000 minus $75. So it can make a difference. All right. The other thing is with your long-term care planning. If you're trying to qualify for Medicaid to pay for nursing home care, an individual cannot have more than about $2,000 a month in income and $2,000 worth of assets. You can plan around that. A lot of people don't, they just say, I can't qualify, but you can plan for that. And so, but when you apply, you've heard of a 5-year look-back period? So they get to look back 5 years, and they're looking to see if you made transfers for less than fair market value. Okay? So they're able to take 5 years worth of your bank accounts. They'll look at your property records. They're already tied into the IRS. And so they can ask for all of that documentation, and then they add up the gifts. If you sold a $300,000 house for $100,000, that's a $200,000 gift. And then they calculate a penalty. The penalty is usually based on the average cost. So if it's $10,000 a month, you divide 200 by 10, you got 20 months of disqualification that you have to pay the full amount for the nursing home care before you can qualify. I just let you know that you can do planning so that you can preserve your assets and qualify for Medicaid, whether you have extra income or extra assets. The house is an exempt asset, but if you haven't planned for it, when they die, they want to get paid back, and so that's where they can put a lien on your house. You may have heard about that. All right, let's see what else. Beneficiary designations, like the life insurance and the retirement accounts. If it goes directly to an individual, then if you have an irresponsible spender, it's not protected. Okay, if you have younger beneficiaries, then it's protected until they turn 18, but you can't control it once they turn 18. So if you've got $100,000, $50,000 or $1 million in a retirement account, and an 18-year-old inherits it, what do you think they're going to do with it? And how long do you think they're going to have it? And then you can have grown people. You know, they have irresponsible grown people, or people who have substance abuse issues. So you may want to protect that. And then another way to avoid, I mentioned, was trust. And trust, and by using a trust, a properly funded trust, you are transferring your property from your name into the name of the trust. All right, so I think we talked about the pros and cons. Oh, I want to talk about the, yes, sir. No, so the question was protecting property that's given to irresponsible spenders, and what's the vehicle to protect? And that's what I'm moving into right now, outright gifts versus gifts in trust. All right, so an outright gift, it goes directly in the person's name. All right, a gift in trust, you put it into a trust for the benefit of the person. All right, and so we mentioned with the will, it's a public process, so people know what you've designated for different people. But what I like to use as an example is the school bus trust. So if you've passed and you've left your property to your spouse or a child, and maybe they're out driving and they're distraught because you've died, it's raining, they're not paying attention, they blow a stop sign and hit a school bus. Kids get hurt, there's a lawsuit, and so you've got creditors from the lawsuit. First line of protection is that automobile insurance. But if you've got a traumatic brain injury or a death or something like that, that can exceed the amount of automobile insurance you have. And so then they're going to go after whatever's in that person's name. So if you've died and left them an outright gift, or they're the beneficiary of your life insurance, they get a check. Once they get that, that's property that's in their name. And so creditors can go after it. A trust is a separate entity. So you can say, when I die, put this property in a trust for my spouse, in a trust for my child, and it doesn't have to be an irresponsible spender. If you want to protect it from their creditors, a creditor can be a divorcing spouse. You know, you don't want your deadbeat in-law, son-in-law, daughter-in-law to get half. And in family law, inherited property is not considered marital property, but all the earnings and other things that come in are. So if they've inherited your family house, and then they've used the money that somebody earns to fix up that house, you've muddied the waters. Okay, and so if they're divorcing, they may be trying to take that property that's been in your family. So by leaving it in trust, you can also have what's called a spendthrift provision, and that says whatever that I leave to you in this trust cannot be used to pay your creditors. Okay, it cannot be used as collateral to buy that Corvette. It can't be used if you go bankrupt, okay? And you can still give your beneficiary access, because with a trust, you have three players. The creator, so that's the trust maker, that's you. And then you have the trustee, that's the person you designate to manage the property. And then you have the beneficiary. So when you're alive and well, you create a trust today, or before you create the trust, you own your property, you manage your property, and you manage it for your own benefit. Okay? After the trust, you're the trust maker. You are also the trustee who manages it, so you're still in charge, and you're the beneficiary. So the only difference is legal title. Okay, you can still do whatever you were doing before. Now that's a revocable trust. There's also irrevocable trust. And those are usually for asset protection. And so a lot of people make the mistake of thinking that a trust protects their assets from creditors. So a revocable trust does not. Otherwise, everybody would go buy stuff, put it in a trust, still be in charge of it, and say, I'm not going to pay my creditors. That's fraud. Okay, so irrevocable trust, one is like the Medicaid Asset Protection Trust. You can use an irrevocable trust and transfer property that you want to protect if you become disabled and need to qualify for Medicaid, as long as you've put it in there, and we've got that 5-year look-back period, you've put it in there, it's there for 5 years, something happens in the 6th year, that property's protected. But going back to protecting for the irresponsible beneficiaries or young or disabled, by putting it into the trust document, I talk in 3, so you've got the trust, which is your bucket or treasure chest where you put all your property. Then you've got the trust agreement, that is basically a book of instructions. Oh, look, here we are. And we're at revocable trust. So the trust agreement is, so that container is your trust bucket. And so it can own anything that you can own. It can own your house. The dollars represent your bank accounts. It can own your business interests, your investments. Okay? And so we mentioned that life insurance and retirement accounts, those are on the outside. You don't put them in the trust. Does this clicker work? They're doing a good job, though. And then you have lifetime distributions. That's what the spigots represent. And then you've got death, after death distributions. That's the second. Oh, no, I'm sorry, principal and income. The first spigot is principal. That's the property that you actually put in there. And the second spigot is income. So if you have property that's earning dividends or property that's earning rent, and because this is a revocable trust, it's invisible for tax purposes. So any income is taxed on your Social Security number. And then after you die, it becomes irrevocable so that nobody can change what you've put into place. Yes, ma'am. Okay, so the question was, can you put, we lost our PowerPoint, but can you put mortgage property into a trust? And so yes, especially if it's your residence. There's a law, because with mortgages, there's usually an acceleration clause that says if you transfer this property, then all the money, the mortgage becomes due. But there's a law called the Garn-St. Germain law that says you can transfer your house into a trust without the acceleration clause coming into play. Okay, does that answer your question? Yeah. And so, yes, so then with the revocable trust, the lifetime beneficiary is you. And so then you see this escape hatch at the end. When you die, that's where it can go. Your property can go to people, like your spouse or your children. That second container is a trust, but you see it has a blue lid on it. That's an irrevocable trust. Once you put the property in, the trust maker can't take it out. Okay, and so only the trustee can distribute the property. And then the last is an entity. That can be a charity, your church, your college, Morehouse I see over there, Zion Hill. So any of those can be your beneficiaries. And then that trust, you can put rules on it. You can say that your beneficiary can be their trustee. If they're irresponsible, you can say they cannot be their own trustee. Someone else has to be their trustee. You can also have special needs trust for if someone like my sister has Down syndrome, you put, instead of putting it in a general purpose trust, you put it in a special needs trust. That way the property will not be counted against them when trying to determine whether they can qualify for means-tested government benefits. But it'll be there for their use. And someone else has to be in charge of it. So we talked about the three parties. the trust maker, the trustee, and the beneficiaries. We've got 3 phases of life. So when you are alive and well, then you are the trust maker. You're always the trust maker. You are also the trustee, and you can designate someone to be the co-trustee. A lot of people, when they get older, they add their children to their accounts. When you do that, you're making that person a co-owner. So if they get sued, your property is subject to their lawsuits. If they're irresponsible, your property is subject to their lawsuits, their spending. If you have to go apply for Medicaid, you've made a gift of your property to your children. So adding someone's name to your account is not necessarily the best way to do that. You can use a power of attorney to give them power to make withdrawals, but not ownership. And you can use a trust. You can make them co-trustee, and you can say that both of you have to sign the checks, or you can say your co-trustee can sign without you. So you get to make the rules. The trust agreement is basically a book of instructions for how you want the property that's in the trust managed. So while you're alive and well, you're the trust maker, you are the trustee, which is the manager, and you are the beneficiary. If you become incapacitated, you have already named successor trustees that you want to take over management if you can no longer manage your property yourself. And so that helps you avoid the court process of guardianship and conservatorship. And so your successor trustee, and you are still the beneficiary. So they have to manage the property for your benefit. And then after you die, again, you're still the trust maker. Then you've named successors. They can be different or the same as the incapacity trustees. And you can have joint successor trustees, or you can have in succession. It's always good to name backups. And then the beneficiaries are the people you designate, whether it's the church, a trust for somebody, people, a trust for people, or another entity. Does that make sense? Yes, sir. Okay, so the question was, by putting property in the trust with the 5-year look back, can they still look at it? So that's a different trust. This is a revocable trust. The Medicaid Asset Protection Trust is an irrevocable trust. And so the 5-year look back period, it has to be there 5 years before it's protected. Oh, glad it's just water. And so once it's there 5 years and 1 day, if something happens, then it is protected. Okay, so, yes, ma'am. Say that again. No, so with the revocable trust, you can do whatever you want. It's revocable. You can put property in, you can take property out. Your creditors still can get to it, just like if you can get to it, your creditors can get to it. The irrevocable trust, like the Medicaid Asset Protection Trust, you put the property in, you can't be the trustee. Someone else has to be the trustee, because it's a control thing. If you have control over it, then it's not protected. All right, so, and you have lifetime beneficiaries. You also are not the lifetime beneficiaries. So the way the Medicaid asset protects, it can be sold. The trustee can sell it, but and you still have the right to live in it, but the proceeds from the sale go into the trust. Okay, that's the irrevocable trust. The revocable trust, you can do whatever you want. Put property in, it's just like it's not there. Okay, the only difference is it's not in your name anymore, and that's how it avoids probate. And then it has that continuity. If you become incapacitated, there are your successor trustees who you have named, instead of having to have the court do it or family members fight over it. You've already designated who you want to manage the property. And then when you die, the same thing. Does that answer your question? Okay. All right. So, so I think that's pretty much it for trust. When we talk about, let me see where we are. Okay. So when we talked about those threats to the trust or threats to your assets, so one of the things it does is provides management and creditor protection for your beneficiaries. If you leave a gift outright, it's not protected. Okay, so they can do whatever they want with it. All right? And then the other thing is we talked about blended families and surviving spouse remarriage. All right, what a lot of people do when couples do when they do their planning, they go to the attorney, and spouse number one, I'm going to say husband and wife to differentiate. The husband says, when I die, everything goes to my wife, and if she dies before me, it goes to our children. A lot of people do that. And then the wife does the same thing. So they have reciprocal plans. The wife says, when I die, everything goes to my husband, and then if he dies before me, it goes to our children. Okay, so in my scenarios, the wife always dies first, because you guys know about the casserole ministry. So the wife dies, and then the ladies on the casserole ministry start bringing the widow the casseroles, and he falls in love with the best casserole maker. And she has children from another marriage or another relationship, and they get married, and they go to the attorney. He has now inherited all of the first wife's property, and they go to the attorney and do the same thing. We're one big family. He says, when I die, everything goes to my wife. She's going to take care of the kids, and if she dies before me, it goes to all of our children. And she does the same thing. Now the husband dies. And wife number two gets everything. And then wife number two says, I never did like his other children. And she changes the plan. So when you do plan with a trust, and there's some people do the same thing with their trust, they still leave everything to the spouse. And so you got to plan it the right way. You've got to have an attorney who asks you the right questions. And so when you plan with a trust, you can set aside for your kids, and when you die, it becomes irrevocable. So everything that you've put in place stays in place. Okay? All right. And then we talked about substance abuse issues. A lot of times people want to disinherit the person who has a substance abuse issue because they don't want to feed the habit. They still want to provide for them. And what a lot of people do is say, a lot of people plan by giving things to the oldest or leaving the insurance to the oldest. Well, when the oldest or whoever that person is receives it, it is theirs. Okay? And they may be a person who's going to do the right thing. They may be a person who feels like, I took care of mom, I took care of dad, so I'm entitled to more. They may be on hard times, so I'm going to spend it now and I'll take care of it later, and later never comes. You have to plan the way you want things to go, okay? And so for that child or other loved one who has a social disability, you can say it goes into trust, and then the oldest or someone else can manage it for them. And that person is a fiduciary and has a legal obligation to protect the beneficiary and protect the assets for the beneficiary. Let's say other planning tools. Financial power of attorney. So financial power of attorney is for management of property that's not in trust. Okay, they can be limited in time, or they can be durable. So when you hear of a durable power of attorney, you have to have capacity when you create any of these plans. And so if you lose capacity, durable means it continues to be in effect. All right. It can also be limited to a transaction. So, and I'll give you an example. When my sister and her husband were buying their first house, they were out of town on the day of the closing. So they gave a limited power of attorney for my mother to be able to sign on their behalf at the closing. And then her power went away. So it was limited to that single transaction. So you can put limitations on the power. You can put limitations on the time. Maybe you're going out of the country. Maybe you're in the military. So you want somebody to manage while you're gone. You can also make them effective immediately, or what we call springing. It becomes effective when a certain event occurs, like if you become incapacitated. And when you're doing your planning, you can say how that incapacity is determined. You can say, I have an incapacity panel that includes my medical provider, and together they can make the decision and certify. Or you can say, when you do your planning, you're in control. And you're also kind of maintaining control when you lose control, because you've put in place what you want to happen. Another tool is the Advanced Directive for Healthcare. So that's where you designate agents for your healthcare power of attorney to make medical decisions when you can't make those for yourself, when you can't communicate them. So you've designated an agent. You should select someone who knows what you would want and would honor that, and then they can work with the doctors. They can make decisions on your behalf. The other thing, Georgia combines the documents. There's, you've heard of a living will. A living will is not a will. It's a designation of what you want done if you're in an end-stage condition. So in Georgia, it's an advanced directive. In Georgia, the advanced directive combines the statutory form, combines the healthcare power of attorney that designates the agent, and the living will provisions. So the living will provisions are if you're in a terminal condition, so maybe you're on life support, and two doctors have said that we have you on life support, it's keeping you alive, but we can't make you better, okay? And if we disconnect, you'll probably die in a short period of time. Okay? Then you get to say what you would want done if those circumstances occur. Do you want them to continue treating you, pull out all the stops? Do you want them to allow you to die naturally but keep you out of pain? Do you want something in between, a ventilator, hydration or nutrition by tube? So you get to say, and that helps by giving instructions for your loved ones so they don't have to make that decision themselves. Okay, I had a friend who was telling me about when his mother died. Okay, it's Q&A. Well, we're right at the end too. So the last tool is the HIPAA release. You know how you go to the doctor and they give you their privacy statement. Okay, so the privacy statement says that they can't give out your confidential medical information without your written permission. So the HIPAA release is that written permission. It does not give anybody you've listed any power. It just gives them, the people you named, the ability to go to the doctor and request information about you. Okay? And a lot of times, like with my clients, I list myself with their permission only for capacity determination. I can't get in your business otherwise. But that way, if somebody brings you to my office and says she wants to change her plan and leave everything to me, like a caregiver. When my dad was in an assisted living facility, there was a nurse who used to take him to the bank. And she also used to sell noni juice. He had a closet full of noni juice. And I finally said, look here. So I told him she's not allowed to visit. And so the HIPAA release does not give any power. It gives authority, and like what I was saying is if I'm on there, I can reach out to the doctor and say, because you have to have capacity to do your planning. And so like when my dad had Alzheimer's, he was able to do his planning because you can have what's called moments of lucidity. And so you have to know what you're doing at the time you develop the plan, and at the time that you sign. Okay, and so the attorney is responsible for, we're not medical doctors, but we ask questions and all that kind of stuff. The other thing about meeting with attorneys, I have a lot of people who call me and say, I want to make a power of attorney for my mother. The only person who can make the power of attorney is the mother, because you're giving the power. The client is the person who's making the tool and giving the authority. And so a lot of times, adult children get offended. I'm like, you have to sit in the waiting room while I meet with your parents, and then with her permission or his permission, you can come in, because we have to ascertain that there's no undue influence, that you're doing what you want to do. I had a daughter and son call me. They want to make a power of attorney. They want to make a trust for mom. And I was like, well, you can't do it. I got to talk to your mom. Can we call her? I said, yes. Mom said, I have a will. I've given everybody a copy, and I'm not changing it. I said, that's the beginning and the end of it. The son was like, can I say? Nope, you can't say anything. So you have to have capacity, and you have to, there has to be no undue influence, and we do these things to protect you. So if you're bringing someone, don't get offended if the attorney says you have to wait in the lobby. So the other thing, I think that's about it. Sorry I didn't have my stuff together, but it's time for questions and answers. Oh, one other thing, sorry. Married couples. Okay, how many people are married? Okay. And some may have been married a little short amount of time, some a long amount of time. But have you always agreed 100% with your spouse? Okay, so there are inherent conflicts of interest. So whenever you are doing planning with your spouse, you are entitled to get separate attorneys. But you can also use the same attorney. You just got to waive conflicts of interest, because attorney-client privilege will be between the three of you, and there will be no secrets between the three of you. So if one of you later calls the attorney and says, I want to change such and such, but don't tell my spouse, then the attorney is supposed to recommend to you that you get separate attorneys. I had a situation once where one spouse was doing planning by himself, and he was trying to be protective. Okay, somehow the other spouse found out about the meeting, and it was on Zoom, and she came, and I asked him if it was okay, and he said, yeah, I have nothing to hide. And so when he started naming his agents, he did not name her as the financial agent, the trustee, the power of attorney, and she got mad. And it turns out, she had gone through bankruptcy, so he was trying to be protective. He wasn't trying to hide anything or anything, but you got to think about those things, because she stormed out of the room, and the next week she filed for divorce. And so think about those things before you get in the room, how you want to do it, okay? Because he didn't have anything to hide, but he could have done that plan and it be in place if she hadn't shown up and he let her in the meeting. So you have to think about your dynamics and then proceed accordingly. Yes, ma'am. So it's questions and answers, yes. Yes, so the question was, if there are two people who have joint property, can one have a trust without the other? And the answer to that is yes. Even if property is titled as joint tenants with rights of survivorship, the rights of survivorship don't kick in until you die and there's a survivor. So one person, if you have two people on the property, whether it's joint tenants with rights of survivorship or tenants in common, one person can sell or transfer their share. So one person can transfer their share to a trust, one person can sell their property to someone else or transfer it to someone else. And so it's always important to know how your property is titled. And that leads to another thing. It's important. Planning is not a one and done thing, okay? Because we know life changes. We know the law changes. We just had the big, beautiful bill. So the estate tax exemption once upon a time was $100,000. It was supposed to go to $5 million this year, but now with the big beautiful bill, it's $15 million. So unless you have $15 million worth of assets, you don't have an estate tax. Okay? A married couple, that makes it 30. Any other questions? Did you have a question? Oh, you had a question? Okay, so the question was, probate can become very expensive. What are the costs for probate versus the costs for trust? And so costs for probate will depend on whether you use an attorney and what your attorney charges. Some charge hourly, some charge a fixed fee, some charge a combination. With probate, you've got the court fees. With trust administration, you don't have the court fees. With probate, you have the publication fees, you have the attorney's fees, and you have the executor's fees. With trust administration, you can say whether the trustee gets paid. It is a job, but you can say, especially if it's a beneficiary. Now, if you have a corporate, they get paid. And there are statutory limits on what they can get. It's a percentage. If you have maintained your trust and kept it up to date, and so when you're looking for an attorney, like we're putting a maintenance program in place, and what that does is we review every year to make sure, people go to the bank and they undo things. The bank officers say, oh no, you should do this instead, and then they change what I worked hard with you to put in place. And so we review it to make sure that you, A, have funded it, because step one is to fund, if you use a trust, to fund it. And step one is to create it, and step two is to fund it. And what happens is, and it's not just with me, but attorneys in general, attorneys will fund the residence included in the planning and give you instructions for funding the rest, and you can hire them to fund the rest, but nobody wants to pay the attorney any other money. And so then when you talk to them in a few years later, and you ask them if they funded it, oh, I thought I was done. And so, or you die and you haven't put a bank account and everything's on freeze and your beneficiaries here is, the bank won't talk to me. I don't know if there's $200 or $200,000 in this account. And they've paid to go through probate to find out there's $2 in the account. Okay, so you got to keep things up and maintain it. We're wrapping up. Are there any other questions? How many questions can I? Okay. Yes, ma'am.
You leave your property to your children or child, and then they enjoy the property, but they don't want to pay their tax. Can that be a provision made where money is set aside to pay the tax every year? Otherwise, they'll lose the property, not paying tax.
So the question was, if you leave property to your children and they don't want to pay the tax, can you set aside so there's money? And the answer to that is yes. With your planning, you can be creative. You can give somebody a right to occupy. And but when we talk about leaving money for taxes, how long is that going to last? Okay, and there are a lot of people who wait years because they got grandma's good homestead exemption tax, and then when they decide to sell the property or to finally transfer the property, the state wants that money. Okay, so there's things that come into play. All right, that's it. All right, thank you. I apologize for the technical difficulties.
Be sure there should be barcodes with the survey. Be sure to scan the barcode and give the excellent comments on the presentation. We appreciate Attorney Duckett, and thank you so much, and enjoy your
Thank you. And we take 5-star reviews on Google, but I also am having seminars in, if you leave your email address, I have a newsletter that goes out every 2 weeks, but we're going to have seminars the 24th and the 26th at the Holiday Inn Express on Virginia Avenue. It's a free seminar. The 24th is 10. Oh yeah, and right, my QR code is on there. And so you're welcome. We're going to start doing those monthly.
I understand that when you get divorced, my husband and I, we did separate wills and power of attorney and all that, but of course everything went to each other. When we were divorced, I've had my stuff redone. I had heard that in the state of Georgia that when you're divorced, that automatically
The spouses.
okay, so that is that,
Oh. Thanks.
that's a legal.
How's everybody doing this morning? We apologize, we're running just a little bit late because the information was so wonderful, everybody had questions, so we're going to try to be on time this time, but we'll see how it goes. My name is Mary Humphrey. I am a member here at Zion Hill, and we're very blessed and fortunate. We have Attorney Dion Duckett as our presenter, and she's going to talk to us about estate planning with a focus on wills and trust. And I'll share a little bit of information about Attorney Duckett. She has worked in estate planning and elder law and is licensed to practice in the states of Georgia, Maryland, and the District of Columbia. Her interest in and dedication to the practice in these areas, it comes from her relationships and experiences with her father, who died of Alzheimer's disease, and her sister, and she has a nephew who both have Down syndrome. She has firsthand experience, knowledge, and understanding about the challenges that individuals and their families face caring for aging or disabled family members. Dion's goal is to help her clients gain peace of mind by providing quality legal services to address specific needs. And she is a wealth of information. We really appreciate her dedicating her time and expertise with us here at Zion Hill. And with that, we'll turn it over to Attorney Duckett.
All right. Thank you. And I thank you for having me here. We are going to hold questions to the end. All right, that way we can get through it. And I also want to introduce my brother, Jason Duckett, who works with me in the firm. All right, and so today I don't see my presentation. Oh, there it is. Okay, we already talked about who I am. It's not working. All right. Okay, here we go. So I like to start with the question about what is your estate? Anybody? Yes, sir. Say that again? Yes. I heard property, cash, assets. So your estate consists of everything that you own. All right? And it also involves your values, your loved ones, and your legacy. And so when we talk about legacy, we're talking about what you leave behind. We keep losing it. But basically, why would you want to do your estate planning? Oh, here it is. Why should you plan? Okay. Okay. I heard someone say that to make sure that your property gets transferred to who you want instead of the state saying, and that is absolutely correct. And most people think about, when they think about estate planning, they think about what happens to my stuff when I die. But you also have to think about what happens if you live. What happens if you become incapacitated? As adults, we have lots of responsibilities, and sometimes in addition to taking care of ourselves, we take care of other people. We work, we pay the bills, we have kids, we pay their bills, and we take care of their care. We take care of ourselves. So what happens if you become incapacitated and you can't do that for yourself? Or you can't do that for the people you take care of? Do you want the state to appoint someone, or do you want to select who you would want to handle those responsibilities? So one of the reasons is to designate who you want to manage the people and the things that you manage, who you want to manage your care if you become incapacitated, who you want to manage those you care for, and then also where you want your stuff to go when you die. That's so far away I can't see it. And then the next question is, who should plan? Okay, I heard someone say everyone. So that's almost right. Everyone age 18, every adult age 18 or older. Okay, because a lot of times people say I don't have stuff, but like we said, it's also about planning for incapacity. So if you become incapacitated and you can't make decisions about your medical care, you can't make decisions about your property, then do you want the court to designate who can put that person in place? And when you go through the court process, so for property it's conservatorship, and for your personal care it's guardianship, that person, in addition to having the responsibilities for you, they have to report to the court every year. They have to keep inventories, do annual returns, post a bond, usually pay attorneys. Thank you. All right, so, and you may end up with someone who you wouldn't want in your care. Take my family, for instance. We're very close. There's 7 children, okay? And so some of us might be better with money than the others. Some of us might be better caregivers than the others. And so you might have somebody who you would want to take care of you, but you wouldn't want them to manage your money. Or you might have somebody who you would want to manage your money, but you wouldn't want them to be the person making decisions about your care. So you want to decide. Sometimes you may have a situation where the person who you want to do these things doesn't have resources, but the person who you don't want to does. Well, you know, that may give them an advantage in court, and the judge doesn't know any of them. So they're looking at you on a one day. So when we say who should plan, anyone over the age of 18 or older, and planning is not just about planning for death. And so those of you who may have children going to college at age 18, so up until now, you've been in charge of the doctor. you've been in charge of the money. So if you're in an accident, we had a family friend, 27, 30 years old, who was in a car accident with a drunk driver driving the wrong way. And he was in a coma, new job, new apartment, new cable bill, new utilities, and he was in a coma, so he couldn't make any decisions. He did get better, but before that, parents were trying to stop the bleeding, cut off the utilities, cut off the rent. They said, where's your power of attorney? Okay, so they don't have that authority unless someone has given them that authority legally. Then, threats against your estate. So, protecting your assets for your loved ones, for yourself. Some of the threats are incapacity. So what happens if you become disabled? Medical expenses can be very expensive, so you want to do planning to, or if we talk about, long-term care. How many people know how much nursing home care costs? Okay. On average, in Georgia, it costs $10,000 a month. And in-home care, full-time, can be even more expensive. So a lot of times the ways to pay for it, out of your life savings, out of having family members help, long-term care insurance. They say the sweet spot for long-term care insurance is between the ages of 55 and 65. That's the best way to pay for it if you are able to get it. The older you get, the more expensive it gets, and the more challenging it is to get it. And then there's applying for Medicaid. And Medicaid, not Medicare. Medicare is based on paying into the system, your FICA, but it does not cover. It covers rehab up to 100 days. It may not even cover 100 days. Medicaid, and you can think of it in terms of the word aid on the end, that's government assistance, and it's means tested. You can't have more than $2,000 worth of assets. You can't have more than $2,000 a month in income. A lot of people have more than that, and so I bring this up to let you know that you can plan. And that's a whole nother presentation. But you can plan so that you can qualify if the time comes. So you can deal with that excess income and you can protect assets. Immature heirs. And you've got immature heirs and you've got irresponsible heirs. They can be the same thing. So you can have a 40, 50-year-old who doesn't know what to do with money, and you can have a 16, 17, 18-year-old who doesn't know what to do with money. We'll get into each of these. Spousal remarriage. What happens if you die and your spouse gets remarried and you have children? Blended family, similar issues. Irresponsible spenders, we talked about that, and substance abuse issues. A lot of times people want to provide for someone who has problems with alcohol, problems with other substances, but they don't want to feed the habit, and so they disinherit. Well, with a trust, you can put it in a trust for someone else to manage for them without having to disinherit them. And then the last thing is self-serving caregivers. A lot of people struggle as we get older, and you have caregivers who are spending a lot of time with you, and they get to know you and they get close. And so, my dad used to bring lunch to the bank because they were taking care of his money. And there was a nurse who used to sell him noni juice. He had Alzheimer's. He had a whole closet full of noni juice. So we had to stop that. So there are two. And when we think about the documents are the tools. So when you do your planning or you work with an attorney, people call and say, I want an irrevocable trust. They usually want a revocable trust, but they call and say, I want an irrevocable trust. Or they say, I want this. What you should do when you're working with an attorney and when you're thinking about what you're doing is what your goals and objectives are. The documents are the tools to accomplish that. So you may not need a trust, or you may need a trust to accomplish. You may need a revocable trust. You may need an irrevocable trust. You may need a combination of the two. But it should be a process. It should be a counseling process. Your attorney should be asking you questions, pointing out what could go wrong, and then you get to decide what you want to do about that, or if you want to do anything about it, but you should be making informed decisions. So a will is a legal document that deals with basically the distribution of your property and winding up your affairs after you die. A will is required to go through probate. A lot of people think that the person named as the executor can just take the will and do what the will says do. That's not the case. The word probate means to prove the will. So the will has to be submitted to the court with a petition, and it's like filing a lawsuit. It is filing a lawsuit. Notice has to go out to let people know that the will has been filed. That gives them the opportunity to object to the will. And then notice has to go out to debtors and creditors, so the creditors can file claims against the estate. And the probate process in general takes about 1.5 years when nobody's fighting. The minimum amount of time in Georgia is about 8 months if everything's going smoothly and everybody signs everything and everything's working. If you're fighting, it can take a lot longer. Costs associated with probate are court fees, newspaper publication fees. If you have an attorney, attorney's fees. If you're fighting, a lot more fees. And the executor or administrator is entitled to a commission, 2.5% of the assets that go into the estate and 2.5% of what goes out. That doesn't always come out to 5%, but that's about 5%. And then 3% of assets that are transferred, like if a house, instead of being liquidated or sold, is transferred to someone, it's 3% of that. So, and then attorney's fees can vary. We talked about what a will is, and so a will is only effective on death, okay? It is not effective before then. Probate is required. Probate property versus non-probate property. It's easier to talk about what non-probate property is, but probate property is property that's titled in your name alone at the time of your death. Okay, so the types of property that are not probate property and don't have to go through the probate process are property owned as joint tenants with rights of survivorship. So when one owner, it can be more than two, when one owner dies, the surviving joint tenants automatically get it, and it doesn't have to go through probate to transfer that title. Okay? If it's titled tenants in common, then people can own different shares. You know, one person can own 25%, one person can own 75%, or a third. And one person can sell their share. Well, you can even do that with joint tenants, but there's no automatic. It has to go through probate in order to get transferred, even if it's in the will that it goes to a certain person. Georgia has come out with a transfer on death deed. It's kind of like a beneficiary designation. Came out maybe 2 years ago, but the legislature is still working on some of the rules about that. But one of the things, so that's a way to basically designate a beneficiary. There's no transfer while you're alive, but all the requirements of the law have to be met within 9 months. A lot of people don't start probate until 1 year, 2, 3, 10 years later. So with the transfer on death deed, it does not go by the transfer if it's not done on time. Cost of probate. So I talked about the fees and everything. So this is an example. If you have cash assets of $100,000, a savings account with 50, checking account with 25, CD with 25. Non-cash assets, investments, $300,000, $50,000 in investments, $250,000 in the house. So you got an executor commission based on what I told you of $14,000. That's 2.5% of what went in, the cash, 2.5% of what went out, and 3% of the value of the non-cash assets. And that's before, so that doesn't include the court fees, attorney's fees, publication fees, other fees. So and then did we talk about the probate process being a public? Once you file that petition in the court, anybody, your next door neighbor, your arch enemy, they can go to the court and pull the documents and see what they say. All right, and so those people who are calling you 10 times a day to buy your house, I had somebody call me to buy my post, or they sent me a text to buy my post office box. They don't even look at what they're trying to get. Let's see. Okay, I want to talk about, I'm not sure what happened Okay, we were at wills. Oh, I'm hitting the wrong button, sorry. I thought I was going backwards. Okay, cost of probate. All right, so when we talk about avoiding probate, there's lifetime gifts. Then there's the joint ownership with rights of survivorship and beneficiary designation, and then there's trust. So we said probate property is property that's titled in your name alone at the time of your death. A trust is a separate entity. So if a trust owns your property, you don't own your property. That's why you're able to avoid probate with the trust. I want to talk about problems with lifetime gifts. Something you want to consider if you're making a lifetime gift of appreciated property, that can be stock, that can be a house, is capital gains tax. So I like to use my parents' house as an example. They bought their house in '72 for $75,000. Now in 2026, it's probably worth $575,000 or $675,000. And so if they were to sell the house today, we know there's exemptions and that kind of stuff, but the calculation starts at what they paid is called the basis. What they sell it for is the fair market value. So if they sell it for $675,000, you subtract the basis of $75,000, the tax calculation starts at $600,000. Okay, any exemptions are then taken and stuff. But if it's rental property, there's no, that homestead exemption isn't there. Okay, so lifetime gift, if they give it to me while they're alive, so if they gave it to me, I also get their basis. Okay, it's a gift of what they have. And so if I sell it tomorrow for $675,000, the calculation is the same, $675,000 minus $75,000. If I inherited it from one of them today, it's worth $675,000. I get an adjustment in basis to the fair market value of the date of death. So it's worth $675,000 today. I sell it tomorrow for $675,000. My tax calculation starts at $675,000 minus $675,000 is zero. Okay? So if it's 10 years from now and it's worth $1,675,000, then it will be $1,675,000 minus $675,000 instead of $1,675,000 minus $75,000. Okay, so that's a tax consideration with a lifetime gift. Joint ownership. A lot of times people will put children's names on the house. So it does, the pro is that they automatically get it. The con is it's now their property also. You got to get permission from them to sell it. I had a real estate agent call me one time about a neighbor who had put her children's names on her property, and she didn't know she wasn't still in charge. And they wouldn't give it back. So once you make that transfer, you've made them an owner, okay? And so that can make it subject to their debts. That can also, when you're planning for long-term care, if you become incapacitated and you're counting assets, you've heard of the 5-year look-back period? What that means is when you apply for Medicaid for nursing home care, they can look back 5 years. They can get 5 years worth of bank accounts. They're already tied into the IRS. They ask you for everything, and they're counting up transfers for less than fair market value. So if they see in your checking account that you're giving somebody $500 every month, they're going to add that up, and then they're going to calculate a penalty. Right now, the penalty divisor is about the same as a month of care, so $10,000. So if you sell your child your $300,000 house for $100,000, that's a $200,000 gift. They divide it by the $10,000, that's 20 months of disqualification that you have to pay the full amount before you can qualify for Medicaid. So you don't just start giving things away and making transfers. You got to make sure you're being strategic. That's a whole nother presentation, but it's to let you know that there's planning that can be done. When we're talking about proactive planning, we're talking about when you're relatively healthy. You got a diagnosis of dementia or something, or Parkinson's. And so there's a possibility that down the road you may have to go into a nursing home. You do that planning if you have 5 years, because it's a 5-year look-back period, and you make the transfer to the trust. If something happens 5 years and 1 day later, it's protected. Then there's crisis planning. So somebody falls and breaks a hip and they haven't done their planning. There's still things that you can do. With the proactive planning, you can usually protect up to 100%. With the crisis planning, you can usually protect up to 50% because you probably have to make some gifts. But you are planning to minimize the penalty period and maximize asset savings. So for people who have parents or themselves who are planning, know that there are things that you can do still to protect assets. Let's see. Beneficiary designations. Beneficiary designations typically result in an outright gift. And so if you've left so those are usually on things like your insurance or I'm getting my steps in, your insurance or your retirement accounts. And so all they want, it doesn't go through probate, they just want a death certificate and they write a check. So it could be going to a grandchild. It could be going to someone who's irresponsible. It could be going to an 18-year-old. Okay, you can't, once they get it, you can't say, let's put that in a trust. They're an adult and it's theirs. Okay, what's an 18? So in your retirement, your life insurance, you could have $3,000, you could have $300,000. What is an 18-year-old going to do with that money? Are they going to pay tuition, pay rent, or buy a Camaro? So planning becomes important. And it can be a 45-year-old. We got irresponsible 45-year-olds. So you think about what your family dynamics are. And you can have someone like my youngest sister is 39, she has Down syndrome. So we use a special needs trust to provide for her. Whatever's in the special needs trust does not get counted for the government benefit purposes. Let's talk about trust. So a trust is a separate entity. It deals with property only. I like to think of it as a treasure chest or a bucket that you transfer your property into. You can designate agents to manage your property. And there are a lot of different types of trust. There's revocable trust and there's irrevocable trust. Because the trust is a separate entity, the property that's in it does not go through probate because probate property is property that's titled in your name alone at the time of your death. So if it's in a trust, it's not in your name. So it's private. Nobody can look up your trust and see what's in it. And with the planning, with your general planning, we're usually talking about a revocable living trust. Revocable, you can amend it, you can cancel it, you can put property in it, you can take property out. With the irrevocable, you can put property in it and you usually can't, the person who creates it can't take the property out, okay, because that's for asset protection. Hopefully we can get through the diagram. So I talk in threes. With the trust, you have your bucket, that's the treasure chest, bucket, whatever you want to call it. And then you also have, and a trust can own all the property that you can own. So that's your bucket. And so the first house is the house that you live in, your bank accounts, your investments, personal property like jewelry and furniture. It can own your business interest, okay? The second property, that's your rental property. So it can own anything that you can own. You do not put your life insurance or your retirement accounts in the trust. Those vehicles have their own protections built into them. And when we're talking about a traditional IRA or a traditional 401k, what happens when you make a distribution? You have to pay the taxes. If you transfer that to your trust, all those taxes come due at the same time. That can put, if you have a lot built up, that can put you in a higher tax bracket. And and it gets rid of whatever protections that might have been on those vehicles. And then we've got two spigots. The principal is the property that you transfer, and then there's income. So if you have rental property that's earning income, or you have investments that are earning dividends, and so that only the trustee can turn on the spigot. So that gets to the next. So with the trust, the threes, you got your bucket, treasure chest, you got your trust agreement. That's the rules you put in place, who you have as your trustees, who you have, how distributions are made, who are your beneficiaries. It's basically your book of instructions on how you want the property managed that you've put in the trust. And then the third thing is you always have a will, or you should. It's called a pour-over will, because that is the backup. If you haven't maintained it and you haven't funded your trust, funding is putting the property into the trust, you create the plan, then step 2 is to fund it, okay? If you haven't maintained it and funded it, then your will is going to say, when I die, put my property into my trust. It's going to have to go through probate to get there. So the thing you need to do is make sure you fund it if you use a trust. And then the trust will say where it goes after that. So it's called a pour-over will because it's pouring your property into the trust. The 3 parties are the trust maker, that's you create the trust. The trustee, that's the person who you designate to manage the trust. And then the beneficiary, they benefit from the property that's in the trust. So before you create, we're talking about a revocable living trust, living because it's made while you're alive. A testamentary trust is one that's made after you die. So your trust or your will may say, create a trust for my daughter and put the property in it. That's a testamentary trust. Okay, so while you're alive, you own your property. Before the trust, you own your property, you manage your property, and you manage it for yourself. Okay? After you create the trust and fund it, the trust owns your property. You usually designate yourself as the trustee, so you manage it, and you are the beneficiary. So the only difference with the revocable trust is legal ownership. And legal ownership is what avoids probate. Okay? And so, like I said, you can put property in and you can take it out. But just like you have access, so that's the distributions. You have lifetime distributions and then distributions after death. Okay? So, on incapacity, in your book of instructions, you have designated who you want to take over if you become mentally incapacitated and can't manage your property yourself. Those are your successor trustees. So if you haven't put a power of attorney in place, power of attorney is for property that's not in the trust, or a trust to manage your property, and something happens, then you've got to go through the court process and have somebody appointed. And the court can appoint someone that you wouldn't have had in place. So if you do your planning, you get to select. The court may, if your family members are fighting, appoint the county administrator, total stranger. Okay? So that's another reason to do your planning. All right? And so, so there's 3 phases of life: alive and well. When you're alive and well, you're the trust maker. You're always the trust maker. It only gets made once. You designate yourself as the trustee. You can name yourself a co-trustee. Like a lot of people, when they get older, they put a child's name on the account. Well, when you do that, you're making them part owner. That can subject your money to their creditors. If they're not responsible, they can spend it. And if something, when you die, it automatically goes to them. So if you wanted it to go to different people, that's not what's going to happen unless out of the goodness of their hearts, they divide it. So the better way is to do it with the tools of estate planning. If you become, so when you're alive and well, you're the trust maker, you're the trustee, and you're the beneficiary. So the only thing that has changed is ownership. If any property in the trust is earning income, it's taxed to you on your Social Security number. That's while you're alive. All right, if you become incapacitated, then in your book of instructions, you have said who you want to take over, so you don't have to go through the court process. All right, so you can name trustees, and you can name backup trustees, you can name co-trustees that have to work together. And so you are the trust maker, Your successor trustees are the people you named, and still you are the beneficiary. And they have a legal obligation as a fiduciary to act in your best interest, okay? And so then the third phase is death. You're still the trust maker. You've got successor trustees for death to wrap up your affairs. They can be the same or different from the incapacity trustees. And then the beneficiaries are whoever you designate. They can be people, like your children, spouse. They can be, that trust you see has a blue cap on it. That's an irrevocable trust. When you die, your trust becomes irrevocable so that nobody can change the provisions that you have put in there, okay? And so, and then it can be to an entity, like a charity, your church, or your institution. And the trustee, your successor trustees, they have to administer the property in accordance to your book of instruction for your beneficiaries. Now, because this trust is revocable, now only the trustee can turn on the spigots whether you're alive or dead. So if you're the trustee, you can do whatever you want. If someone else is the trustee, they've got to follow your instructions. All right? Now, since there's no lid on the revocable trust, you can remove the property, but there's also access by your creditors. Some people think I put it in the trust, my creditors can't get into it. But if we could do that, and some states have what we call self-settled asset protection trust. That's a whole nother topic, but Georgia does not have it. You cannot buy property, put it in the trust, and think it's protected, your own property, think it's protected from creditors. Okay, it's not. With an irrevocable trust, that's for asset protection. And we'll talk about that later. Let's see. So your creditors have access, you're the beneficiary. And then most of the primary uses, asset management, incapacity planning, probate avoidance, and beneficiary protection. So if you create that trust with the lid, the testamentary trust for someone, so you can protect what you leave to your beneficiaries from their creditors. And a creditor can be their divorcing spouse. A creditor can be, I like to use, I don't know if I have it up here, the school bus trust. Okay, so say you've died and you've left property in trust to your spouse, or you've left property to your spouse. And they're distraught and driving, and it's raining, and they blow a stop sign and hit a school bus, and kids get hurt. Somebody might have traumatic brain injury, somebody may have died. There's a lawsuit. First line of protection is the automobile insurance. But if there's not enough to cover the settlement or the claims, then they're going to go after whatever's in that person's name. So when you make gifts outright to a person, that gift is in their name. If you leave it to them in trust, you can provide protections. And so, because you can have what we call a spendthrift provision, so the property that I am leaving you in this bucket or this treasure chest, you cannot pledge as collateral, you cannot use to pay your creditors, you can only use it for your needs. And we usually limit that to health, education, and maintenance. Maintenance is maintaining your lifestyle, so that's very broad, okay? And then an independent trustee would be responsible for making any other distributions. And because if you can allow your beneficiary to be their own trustee, but if they're irresponsible or young, have substance abuse issues, then you don't want them to be their own trustee. You can put somebody else as the trustee. If it's an interested trustee, somebody who's related, then you limit them to that health, education, and maintenance. And then an independent person is for other distributions. Because anything that in your control, or if it's an interested trustee, you might be able to exert control over that person, then a creditor can go to the court and say, make this person make this distribution. But if you're limited to health, education, and maintenance, that school bus accident is not your health, your education, or your maintenance. And so the independent trustee who has discretion to look at things and decide can look at the situation and say, hey, if I make this distribution to them, as soon as it hits their bank, the creditor can swoop in. So I'm not going to make the distribution. So that's how you can provide creditor protection for your beneficiaries. And you can say, you can say they can be their own trustee. You hear people doing stages when they turn 21, when they turn 35 or whatever. But whatever they're entitled to pull out, the creditor's entitled to force them to pull out if they have power over it, okay? So we talked about the benefits of trust. Management if you become incapacitated, avoid probate, protect families' inheritance. The other thing it does is it promotes family harmony. If you've done your planning, not just with a trust but other things, then with the trust, anybody can sue about anything. But it's easier to avoid the lawsuits with a trust versus a will. Okay? When we talk about promoting family harmony, I'm the oldest of 7. And my parents did not raise any shrinking violets. I used to say they raised all chiefs and no Indians, but that might not be politically correct. But we're all bosses. And so if my dad did his planning, and if he had not said who he wants to be in charge, because we're very close, but there would have been a fight about who's in charge. And so when we were at Murray Brothers, Mr. Murray was like, I'm amazed at how y'all handled that, because there was 7 of us. And he was like, I've seen some things around this table. So it can provide family harmony. You have said who you want to be in charge. You have said how you want things to be done. All right. So these are all the things that we talked about. Plan, avoid, protect, and protect. Other tools for incapacity planning. We talked about the successor trustees. You have your advance directive for health care. So if you become incapacitated, if you become incapacitated, and I have videos on YouTube, if you have become incapacitated and you cannot make or communicate decisions about your care, then you need to have agents already appointed. You can't do your planning after you lose capacity, okay? You have to have capacity to do your planning, and no one else can do your planning for you. So in your advance directive for health care in Georgia, it combines the health care power of attorney and the living will. So I'm going to describe it as health care power of attorney and living will, but it's all the advance directive for health care. The health care power of attorney is where you designate agents to make decisions about your care, where you live, what kind of treatment you get, deal with the doctors, that kind of stuff. The living will is not a will. It's your designation of what you want done if you're in an end-stage condition. So if you're terminal and maybe you're hooked up to life support, and 2 doctors say that our treatment is keeping you alive, but there's nothing we can do to make you get better. All right? And if we stop treating, you'll probably die pretty quickly. So this allows you to say, what do you want them to do? Stop treating, keep treating, pull out all the stops, or do something in between, like a ventilator or feeding tubes or something like that. That's where you get to say what happens, and you don't have to, your loved ones don't have to fight over it. They might still fight over it, but they don't have to figure it out. You've said what you want done. I had a close friend who was telling me about when his mother died, and she was about 95, and she was really sick, in a lot of pain, and she was like, I'm ready to go. He was like, no, Ma. He wouldn't let her go. And so, and then I understand that. You don't want to lose your parent, but Mom has said what she wants. She's suffering. Then the financial power of attorney. That's for property. So financial power of attorney does not work over a trust, because trust is a separate entity. But it's for whatever's not in your trust. So that's like your retirement accounts, your life insurance, other property. You may inherit something, and you got to maintain. You want to then transfer it into the trust. If you're incapacitated, your agent under your financial power of attorney can transfer it in there. So a power of attorney can be limited It can be limited in time, and it can be limited in transaction. And the agents under all of these tools are fiduciaries. So they have a legal obligation to protect the beneficiary or the principal. The principal is the person who created it. Okay, so limited in time, maybe you're going out of the country or you're being deployed in the military and you want somebody to manage your property during that time. So you can put in there that it's for this specific time. Limited in transaction, the example I like to use, my sister and her husband were buying their first house and they were going to be out of town on the week of the closing. So they gave a limited power of attorney to my mother for that sole transaction where she could sign on behalf of them at the closing, and then that power of attorney was no longer good. A power of attorney can be effective immediately or it can be springing. So immediately is as soon as you sign it. Springing is on the occurrence of a particular event. So you can say, this is only effective if I am incapacitated. And then you say how incapacity is determined. And then they have guardianship documents for minor children. And we talked about the trust. So those are your and then the last thing is the HIPAA release. You know how you go to the doctor and they give you their privacy statement. So that document basically says they can't give out your medical information, your confidential information, without your written permission. So the HIPAA release is your list of people who can get information from the doctors. It does not give them any power, just the power to find out what's going on. And that's the things that comprise a comprehensive plan. Those are the things that we just went over. Okay, so you should plan now. You know, we never know when accidents are going to happen or other things, and you should maintain your plan. We have 1 minute for questions. Yes, ma'am. Yes. So the question is, at what point, if a person has been diagnosed with dementia, they're considered incapacitated. And so there's different rules of incapacity for the various tools. Like for a will, you have to know your bounty, which is what you own, and the objects of your bounty, which is your family members and loved ones. And so my dad had Alzheimer's when he did his planning. You can have moments of clarity, moments of lucidity. And so as long as at the time you develop the plan and you know what you're talking about, and at the time you sign the plan, because if you meet with an attorney and you put it all together and then it all goes away, you can't sign it, okay? And so, but as long as you're clear and know what's going on, and attorneys should, you know, I have adult children and family members come to me, I want to make a power of attorney for my mom. Only mom can make a power of attorney for mom, okay? And when family members bring the planning person to the attorney's office, the family members have to sit in the lobby while the attorney meets with the family member to determine, like, if I feel like you don't have the capacity, I know, I'm not going to do your planning, okay? I had a charming man. It was a Zoom meeting, and it was the middle of the day, and, you know, if you talk to him, just like my dad, if you talk to my dad, you couldn't tell he had Alzheimer's unless you got him when he was in his loop. He didn't repeat the same thing 10 times in 10 minutes as if he hadn't said it the first time. This guy, I said, "Do you work, Mr. Smith?" And he said, "Yeah." It was 2 o'clock in the afternoon. I said, "Well, what time do you work?" He's like, "I work 9 to 5. I said, "Well, where do you work?" And he said, "I work where I go to work." I said, "Do you pay your own bills?" He said, "Yes, I pay my bills." I said, "What bills do you pay?" He said, "I pay the bills that need to be paid." I said, "What kind of bills are those?" "You know, the bills that need to be paid." He couldn't tell me. He didn't have capacity. But if you were having a conversation with him, you know, just every day, well, you wouldn't know. And so, but he could not tell me, because he was retired. He was retired, he did not work, and his children were paying the bills. But he didn't know that. So the attorney is responsible. We're not medical professionals. A lot of times we'll say, go to the doctor in the morning, get that certificate, bring that says, yes, they can do this planning. Bring some people, they call it sundowning. In the night, they're not so good, but in the morning, they are. So you can still, if they have capacity, do planning. All right. Sorry. Oh, one more. If you have to go, go. But I appreciate your being here. Okay, so he asked, which trust gives the best protection against taxes? And there's a lot that goes into that, okay? Because with a revocable trust, you're taxed the same way. You need, and you should plan with your team, your CPA, your financial advisor, and the attorney, okay? Because with the revocable trust, you're taxed, it's taxed to you. And so whatever tax planning you would do based on your assets would be the same. It's not the trust that's providing that protection. Yes, sir.
All your, like your money and stuff in a trust, could people invest that money inside the trust? Like, how would that work? Like, you want
Okay, so that's outside the scope. I'm sorry, that's outside the scope of this presentation. The person he asked if you put property in your trust, can people invest in it? So you can put your business assets in a trust. So if people are, just like people can invest in your business when it's outside of the trust, they can invest in it when it's in the trust. Does that help? Okay. All right. Thank you.
All right, thank you so much for coming. We have some business cards. Please remember to do the survey. There's a barcode out there somewhere, or you can access it on the website. But please do the survey when you get a chance. Wonderful presentation. We appreciate Attorney Duckett for giving us
Thank
this
you.
vital information. Thank you guys, and enjoy your next session. If you want a business card, I have some.
Hi.
Thank you so much.
And
Thank you.
any questions, you can follow up with her.
I got something that's been 4 years, especially with COVID in Fulton County.
Good morning. How's everybody doing? Good, I hope. Getting a bunch of wonderful information, I'm sure. My name is Mary Humphrey. I am for anybody that does not know me, I am a Zion Hill member, and we are very privileged and appreciative. We have Attorney Dion Duckett here with us this morning. She's going to talk to us about estate planning with the focus on wills and trust. And this is an area that we put off and we say, I need to, and we don't get around to it, but she has a wealth of information. I encourage you to take notes and be ready to ask some questions if we have time. With that, I'll share a little bit of information about Attorney Duckett. She has been doing estate planning and elder law for a number of years. She's licensed to practice in Georgia, Maryland, and the District of Columbia. Her interest and dedication to practicing in these areas stem from her relationships and experiences with her father, and she'll share additional information about that. He died from Alzheimer's disease. And her sister, and she has a nephew who both have Down syndrome. She has firsthand experience, knowledge, and understanding about the challenges we face when family members have these types of challenges, aging, disability. Her goal is to help her clients gain peace of mind, which is so important, by providing quality legal services to address specific needs. And with that, we'll turn it over to Attorney Duckett, and thank you so much.
All right, thank you. Thank you for inviting me. I think this is my 5th year coming, and so we're talking about planning with wills and trusts. So, show of hands, how many people have done their estate planning or have an estate plan? I see 1, 2, 3, 4, yay, okay. So, the truth of the matter is, even if you haven't done a plan, you have a plan. If you don't make your own plan, the state has one for you. So you want things to go the way you want them to go. So today we're talking about protecting your lifestyle, your loved ones, and your legacy. And we start with you, because just like on the airplane, you got to help yourself first before you can help the others. Let's see, Estate Planning 101. And people take notes and take pictures, but I do have things on YouTube, Duckett Law LLC. My disclaimer, I am an attorney, so all the information today is for educational purposes only and should not be considered legal advice. I have had people who have come to me and done something related to real estate based on something they thought I said, and then they had to also get a real estate attorney. Okay? So I recommend that you always consult a professional. Okay, so we like to start with what is your estate? Anybody? I heard somebody say your house. Finances, yep. So it's everything that you own. So that can be your real estate, that can be your bank accounts, your clothes, your jewelry, all that stuff. If you have copyrights, that kind of stuff, everything that you own. And it involves your loved ones, your values, and your legacy. I've had people ask, what is legacy? That's what you leave behind. That can be your wisdom, that can be your property. So why should you plan? Anybody? So the state won't take over? That's one reason. And so a lot of times people think in terms of estate planning, what happens to my stuff when I die? But you also have to think about what happens if you live. What happens if you become incapacitated? Looking at everybody in this room, we have all either experienced some type of disability ourselves or know somebody who has. And so if a plan's not in place, then you got to go through excuse me, the court process. That can be expensive, time-consuming, and inconvenient. Excuse me. All right. So, reasons to plan are to designate who you want to care for you and your property if you become incapacitated. So who you take care of your stuff now, you take care of your health, you take care of all of that. But if you can't do it, who do you want to do it? If you leave it up to the courts, it could be somebody who you wouldn't have named. It could be a loved one, but not the one you want. Or it could be a total stranger if your family members are fighting. Okay, then the court's going to appoint the county conservator, the county administrator. So, to designate who you want to manage your property when you die and make the distributions. To designate who you want to care for minor children or even adult disabled children. I have a 39-year-old sister with Down syndrome. And so if something happens to my mother, who's going to take care of her? And who would she want to take care of my sister? To give what you want, to whom you want, when you want, and the way you want to give it to them. We'll talk later about outright gifts versus gifts in trust. And so then what happens if you don't plan? So we talked about the possibility of court proceedings. We talked about how the state has a plan for you. So with a will or a trust, you're able to say, I want my property to go to this person, and this is how I want it to go to them. If you haven't done that, the statute says who your heirs are, and it says what percentage of everything they get. And so if you don't have siblings or parents, it could be a cousin who you don't even know, or it could be a remote person, it could be whoever the court, the statute says is entitled to it. Who should plan? Anyone age 18 or older. So a lot of people think that planning is for people when you're getting closer to death, but that is not the case. Even if you don't have property, you've got to plan for the incapacity. So, your adult children who are going to college, if they're 18 years old, you can't make decisions about their finances. You can't make decisions about their health care without their permission. So, they should have powers of attorney and advance directives in place. I always tell people, we had a family friend who was 27, new job, new apartment, new rent, new cable bill, electric bill, all that stuff. He was in a car accident with a drunk driver driving in the wrong lane on the highway. And he was in a coma. And so the parents were trying to stop the bleeding on the bills and the credit, and Comcast said, where's your power of attorney? The landlord said, where's your power of attorney? Fortunately, he woke up, we did the documents, and he's well now. So, but those are the things that can happen. And we talked about estate planning is not just about planning for death. So, threats to your estate. Incapacity. If someone becomes disabled, that can go through your assets really quickly. We talk about nursing home care. Who knows how much nursing home care costs? Right. On average in the state of Georgia, it costs $10,000 a month. Okay, so the ways to pay for it are your savings, family help, long-term care insurance. That long-term care insurance is the best way to do it. My understanding, the sweet spot is between the ages of 55 and 65. After that, it gets more costly and more challenging to get, but it's always good to look into it. Okay? Immature heirs. And immature heirs can be 50 years old. People who don't know what to do with money or property or how to manage it. Or grandchildren who are 14, 15. If they're under the age of majority, they're not going to get it themselves until they become 18. But as soon as they turn 18, so if you've left them something in their name, there'll be a custodian, but on their 18th birthday, it's theirs. And the custodian can't make them put it in a trust or anything like that. They're grown, by the law, and they can do what they want. Uh-oh. I don't know where to point it. I'm hitting the wrong thing. Okay. So, spousal remarriage. A lot of times, married couples go to the attorney. And I use husband and wife just to make the difference between the two. I know there's same-sex couples, but the husband says, when I die, everything goes to my wife. If she dies before me, it goes to our children in equal shares. And then the wife does the same thing. When I die, everything goes to my husband. If he dies before me, everything goes to our children. And so then the wife dies. And so the husband is widowed. Y'all know about the casserole ministry? So the casserole ministry, the ladies in the casserole ministry start making casseroles. And the widow falls in love with the best casserole maker. And she's got kids from her previous marriage or relationship. So they get married, and they go to the attorney, and he has now inherited, let's say, Karen, all of Karen's property. Karen's rolling over in her grave. So he goes to the attorney and says, when I die, we're all one big happy family. I want everything to go to Cheryl. And if Cheryl dies before me, I want it to go to all of our children. We're one big happy family. So Karen's like, see, there's my money taking care of that woman's children. And so then Cheryl does the same thing. When I die, everything goes to William. And if William dies before me, it goes to all our children. So now William dies. He's got all of Karen's property. And then Cheryl says, I never liked Cheryl's children. I mean, Karen's children. So she changes the plan. All right? So you can do that with a will. If you create a trust, when you die, your trust becomes irrevocable. So what you put in place, now if you've done the same thing in the trust, she can do the same thing. But if you've set aside for your children and those types of things, then those things stay in place. So what is a will? There's two foundation documents. And when you contact an attorney, don't call and say, I want a trust or I want a will. You should discuss. They're going to give you a questionnaire. And it's nosy. It asks about all your assets, all your children, all your everything. You need to list deceased children. You need to list divorced spouses. You need to list your property. Your attorney can't help you if you don't tell them what you have. He can't advise you. And then they're going to talk about your goals, concerns, fears, and objectives. And then once they have all of that information, they can make the recommendation of whether you should have a trust, whether you should use a will, whether you should do something else. Okay? So a will is a legal document that provides for how you want your property distributed. It appoints agents, your executor, to take care of the administration. And if you have minor children or adult dependent children, you nominate, and all of these are nominations. You nominate the people who you want to take care of your children. People are under the mistaken belief that with a will, the executor can just take it and do what it says done. The word probate means to prove the will. So you have to probate the will. Every will has to go through probate, unless there's no property to go through probate. And so in Georgia, on average, the probate process takes about 1.5 years. Probate is a public process. Once it's filed in the court, your next door neighbor, those people who are trying to buy your house, they can go pull the records and see what's there. And then there's the cost. There's court costs, there's publication costs, because it has to be published in the newspaper. Notice to debtors and creditors has to be published in the newspaper so the creditors can file claims. The purposes of probate is to protect the beneficiaries and protect the creditors. So the creditors have to be paid before distributions can be made. It designates your preference for guardians to care for your children. And like I said, those are nominations. It has to be approved by the court. So probate is required with the will. Probate property. Probate property is property that's titled in your name alone at the time of your death. So property that's not titled in your name alone does not have to go through probate. So examples of property that are not probate property are retirement. They have beneficiary designations. Life insurance has beneficiary designations. The institution wants a death certificate, and they're going to send it to the beneficiary. If you say the estate, it's going through probate, because the estate has to go through probate. Let's see, beneficiary designations, property that's jointly owned with right to survivorship. That's often bank accounts, so the survivor automatically gets it. Real estate, if it's joint tenants with right to survivorship, and it has to say that on the deed. Now, don't go out and get a deed and write joint tenants with right to survivorship and think that makes it a right to survivorship deed. I had somebody do that based on my presentation. That's why I said this is not legal advice. Then she had to get a real estate attorney. Okay? So, you can also own property as tenants in common. So, if it's joint tenants with right to survivorship, when one owner dies, it automatically goes to the others. So, if it's 3 people, one person dies, it goes to the other 2. Then, when one person dies, it goes to the other one. Now it's probate property unless somebody plans for it. Tenants in common, when one person dies, their share has to go through probate, okay, because there's no right to survivorship. Georgia has now transfer on death deed. That's like putting a beneficiary designation on the deed. So you're not transferring ownership while you're alive. You're saying when I die, it goes to this person. The legislature is still working out the kinks, but the requirements for this deed all have to be taken care of within 9 months of the death. A lot of people don't even start until a year or 2 later. If it's not done on time, then it just reverts to the tenants in common. What else? Okay. I keep doing that. I think I'm going backwards and I'm going forward. So, trust property. A trust, and I'll go over the trust in a minute. A trust is a separate entity, just like an LLC and a corporation is a separate entity. So if you transfer your property to a trust, that's how it's able to avoid probate, because now the property is not owned by you, it's owned by the trust. And we said probate property is property that's titled in your name alone at the time of your death. Okay. And so, Okay. Cost of probate. So we talk about courts costs. There's filing fees, there's other fees, there's executor fees. In Georgia, executors are entitled to 2.5% of cash that goes into the estate, 2.5% of cash that goes out of the estate. That's usually around 5%, but it may not be the same. Up to 3% of the value of other assets. So like if a house is not sold, it's just transferred to another person, it's 3% of that. 10% of the interest earned on money loaned to the estate by the executor. Okay, there's publication fees for the newspaper. I think the prices have gone up. Attorney's fees, that varies. Sometimes there's a bond required, that's insurance in case the executor does something inappropriate. And the time is the average of 1.5 years. If you're in Fulton County, it will take a lot longer than that. Mandatory reporting sometimes. You have to do an inventory and annual returns. And then it's a public process. So here's an example. You have cash assets of $100,000, 50 in the savings account, 25 in checking, 25 in CD. Non-cash assets, $300,000. Investments of $50,000, house $250,000. So the executor commission on that is $14,000. 2.5 of the 100 that went in, 2.5% of the 100 that went out, 3% of the 300. That doesn't include the court costs. That doesn't include the publication fees. If people are fighting, then there's litigation and there's going to be more fees. All right? Now, if you plan with a trust, there's trust administration fees, but you can limit the fees. Avoiding probate. So, we talk since probate property is property that's titled in your name alone at the time of your death. So, you can avoid probate by giving the property away while you're alive. Joint ownership with rights of survivorship, beneficiary designations, or transferring the property to trust. Okay, problems with lifetime gifts. So you've got capital gains tax. That's a tax on appreciated property. That can be stocks, that can be real property. So like if we talk about the house, I always like to use my parents' house. They bought their house in '72 for $75,000. Today, it's probably worth $575 or $675. So I know there's exemptions and deductions and everything. But the beginning point for the calculation, what they paid is the basis, that's $75,000. What they sold it for is the fair market value, $675. So the calculation starts at $675 minus $75. So when they start calculating that tax, you're starting at $600,000, and then you take whatever deductions there may be. If it's rental property, you don't have the same deduction, okay, or property that's not your residence. All right, so if my parents give me the house today while they're alive, then they also give me their basis, the $75,000. If I turn around and sell it tomorrow, $675 minus $75, same calculation. If they've both died and I've inherited the house today, and the fair market value is $675, I get an adjustment in basis to the fair market value. So now my basis is $675. I sell it tomorrow for $675. $675 minus $675, 0. That's where we start calculating the tax. If I sell it 10 years from now, maybe it's worth $1,675,000. We're starting the calculation at $1,675,000 minus $675 instead of $1,675,000 minus $75. So that's just a consideration. So those are things you can, the attorney's job is to point out what could go wrong, and then you decide what you want, how you want to handle it. So, joint ownership. Well, I keep hitting forward when I want to go backwards. The other problem with lifetime gifts can be with the long-term care planning. So, did we talk about the cost of nursing home care? In-home care can cost more. And so the ways to pay for it, well, I mentioned, are your savings, family help, long-term care insurance, which you should look into, or apply for Medicaid. That's Medicaid versus Medicare. And you know by the word aid. Aid is government assistance. Care is based on paying your FICA. Okay, so care does not pay for nursing home care or long-term care. It pays for rehab up to, not necessarily, but up to 100 days. Okay, if they think the rehab's not working, they're going to say, we're not paying anymore. So, in order to qualify for Medicaid, you can't have more than $2,000 in assets. You can't have more than $2,000 a month in income. But that doesn't mean you can't qualify. You can plan so that you can qualify. And so that's a whole nother presentation, but I meet so many people who see my card and say, I should have known you last year when something happened to their mom. So there's proactive planning. You've heard about the look-back period, 5 years. What happens when you apply for Medicaid? So you don't apply to see if you get it. You need to have things in order first. They can look back 5 years. They can ask for 5 years worth of bank statements, including bank accounts that are closed. They're already tied into the IRS, and so they ask for everything, and they're looking to see if you gave things away for less than fair market value. If you sell your $300,000 house to your child for $100,000, you've made a $200,000 gift, and they will calculate a penalty if it was done in the last 5 years. Right now, the penalty divisor is about $10,000. And so what they do is they take that $200,000, add it to whatever else you've given somebody $500 every month, they're going to add all that up. And so the $200,000 they divide by $10,000, that's 20. That's 20 months of disqualification that you've got to pay the full price before you can qualify. So just don't start willy-nilly moving things around without advice. The other thing, and it has to, if you use, so there's the thing called Medicaid Asset Protection Trust. So you plan while you are relatively healthy. You might have a diagnosis of dementia or Parkinson's or something, so the possibility is now there that you'll go into a nursing home. But it might be 5 or 6 years. So if you think you won't need nursing home care for the next 5 years, you can move it to the irrevocable trust. That means you can't get it out. Okay, and somebody else will be the trustee, but you can live in it. And then that is a disqualifying gift, But if it's there for 5 years, and then the next day, the first day of year 6, you fall and break your hip and have to go permanently to the nursing home, it is protected. Okay? They don't count the house when they're trying to get you qualified for Medicaid. But when you die, if you haven't planned for protection, they can put a lien on it. That's where you hear about people losing the property, because they want to get paid back. So if you plan for it, you can protect it. Let's see. And so you don't apply to see if you'll get it, because they're going to determine that disability period. Okay. Then if you don't have 5 years, there is crisis planning. With the proactive planning, you can usually save up to 500%, okay, of your assets. With the crisis planning, you can usually save, a single person, a married couple can save up to 100%. But a single person can usually save up to 50%, because there are going to be, likely going, in the strategy, going to be some gifts made. But what you do with the crisis planning is you're trying to minimize the penalty period and create a stream of income that will cover any penalty period that's created. So that has to be done strategically, because there are things that the money can be spent on. All right. Long-term care planning. So joint ownership. The pro is if one owner dies, it automatically goes to the other. The con is when the last owner dies, then probate is required unless they've planned for it. Now, when you put your children's name or someone else's names on the property, now you've made a joint owner. That includes the bank accounts, that includes, the real estate. I had a real estate agent contact me one time about a neighbor. She had transferred her property to her children. She didn't know she wasn't still in charge. And her children would not give it back. It was theirs. Okay, so you have to know what you're doing. Let's see. So trust. A trust is a way to transfer legal title. You can think of it as a treasure chest or a bucket for the ownership of your property, and you designate agents who are responsible for managing the property. Just like with a business, a separate entity, you have a manager. And it provides instructions for how you want the property in the trust managed. Because it is a separate entity, it's not in your name, it's in the name of the trust, so it avoids probate. Right now we're talking about a revocable living trust. Irrevocable trust and other trusts, those are advanced planning. So it's revocable, that means you can change it, you can cancel it, you can put property in, you can take property out. With an irrevocable trust, you usually can put it in, but you can't take it out. Only the trustee can transfer it out, and that's not you. All right? It can be amended, meaning changed, or it can be canceled altogether. So, I talk in threes. So with a revocable trust, you have 3 aspects. You have the trust, which is the bucket or the treasure chest for your property. It can own anything that you can own, your house, your bank accounts, your investments, your personal property such as jewelry, furniture, your business interests, your LLC, your rental property. You don't want to transfer your life insurance or your retirement accounts into the trust, okay? Because those things have certain protections built into them. And second, because there are rules attached to them that you could mess them up if you transfer them. For instance, with the retirement account, not a Roth, but a traditional. And even if it's a Roth, you don't put it in the trust. But what happens when you make a distribution? Was it paid with pre-tax or after-tax dollars? It's made with pre-tax, the traditional. So when you make a distribution, the taxes are due. So if you transfer the whole thing into a trust, the taxes for the whole thing will become due. All right, and that could put you in another tax bracket. That can do a so if you got $3,000, then that may not hurt you so bad. If you got $300,000, $3 million, and you transfer that into a trust, all those taxes are going to come due. Now, with the benefit, what you would do instead is you would make beneficiary designations to the trust. So you'd say, change it from the individuals. You'd have the individuals as beneficiaries of your trust, and then you would transfer the property. The beneficiary on the insurance would now be the trust. That way you can provide creditor protection for what you're leaving to your beneficiaries, and we'll talk about that in a minute. So people think they can put their property in a trust and protect their assets from their creditors. You cannot do that with a revocable trust. A revocable trust is invisible for the purposes of taxes and your creditors. Okay? That's because you can put it in and you can take it out. So you've got that kind of control. Your creditors can get to it just like they could before you put it in there. You got two spigots, one for distributions of principal, that's the actual property that you put in there, and then distributions of the income, that's if you're earning rent or dividends. And so only the trustee can make the distributions. And you have lifetime distributions while you're alive, and then you've got distributions after your death. So while you're alive, you're the beneficiary. So, and then on death, that's the escape hash. It goes to who you've designated. It can be people like your children, your spouse, friends, family. It can be a trust. You see that one has a blue lid on it. That's an irrevocable trust, because when you die, your trust becomes irrevocable. You may have created a trust for someone else. It is irrevocable because you don't want them to be able to change the rules. You can build in that they can change the rules if you want, give that flexibility, but, and then an entity. That can be a charity like your church or your college or something like that. So you've got the trust, which is your bucket. You've got the trust agreement. That's a contract between the trust maker, that's you, and the agent, the trustee. And it is a book of instructions for how you want the property that's in the trust managed. You get to write the instructions. And then you have a will. With a trust, you usually should have a will, because that's your backup plan. Because the first part is to create the trust. The second part is to fund it. And there's so many unfunded trusts out there. Funding is putting the property in it. And if you don't do that, the property is going through the will, which means it's going through probate, and the will is called a pour-over will, says pour it into the trust. Okay? But now, if your goal was to avoid probate, you have not done that. So you've got your treasure chest, trust, the book of instructions, which is the trust agreement, and the pour-over will. The other thing the will does is it designates who you want as guardians for minor children or adult disabled children. And these are just nominations, because the court has to approve everything. Then the three parties are the trust maker. That's you when you create the trust. Then there's the trustee. That's who you designate to manage the trust. And then there's the beneficiary. Then we've got 3 phases of life. So when you're alive and well, so before the trust, you're alive and well, you own your property, you manage your property, and you manage it for your benefit. You create a revocable trust. When you're alive and well, you're the trust maker. You're always the trust maker. The trustee is usually yourself. A lot of times when people get older and their kids are helping them, they put their kids on the bank accounts. Well, that's making your kids the owner of your bank accounts. If you make them a co-manager, then you're still in charge. Okay, so they can be a co-trustee if you want somebody to have access. All right, and then if you don't like it, you can cancel them. When you make them a co-owner of your account, you can't take them off unless they say yes. Okay, because you made them an owner. And then the beneficiary is you. So when you're alive and well, there's no difference from when before you had the trust. The only difference is legal title. Now the trust owns it versus you, and you can cancel the trust. So you can do whatever you want. Your trustees have to do whatever you say. If you become incapacitated, second phase, you are still the trust maker, but then you've already named successors. I'm getting my steps in. Okay, got time. You've named successors to take over if you become mentally incapacitated and can't manage your property yourself. And that way you can avoid the court process and the expenses and the annual reporting hassle for your loved ones that's required if you have to go through conservatorship proceedings. You can also, with the power of attorney, a power of attorney manages property that's not in the trust. But you got to have these things in place, and you got to put them in place while you have the capacity to do so. So, if you become mentally incapacitated, you're the trust maker. Whoever you named as the successor, and you can name one person and people in succession to act. If the first one can't act, then I want so-and-so to act. Or you can say, I want these two people to act together, and if one of them can't act, then this person steps in place. It's always good to name backups. And then you can also go even further. So this is where a trust, you can put instructions. You can say both people have to sign the check, or one can sign, but they always both are responsible. One can't say, like my brother and I, our trustee is not the one who's here. The other one who's in North Carolina of my dad's, that means I'm doing the work most of the times. And so, but if I do something wrong, he cannot say, oh, I didn't know she did that. He is a legal fiduciary and responsible. So the trustees are backups, and, and when it comes to selecting these agents, you have to select someone who is good with property management. If they're bad with their money, they're going to be bad with yours. And someone who's trustworthy, okay? Let's see. And then the beneficiary is still you if you're incapacitated. So they are managing the property in accordance with your book of instructions for your benefit, all right? And you may say, if you've got a dependent child, that they can also manage it, make distributions for that person. All right, then the last phase is death. You're still the trust maker. You've got successor trustees that you've named in the trust, and they can be the same or different from incapacity trustees. And then the beneficiaries are whoever you've named. So they can be people, another trust, or an entity. Make sense? Okay, I know this is like drinking from a fire hose. So, only the trustees can turn on the faucets to make distributions from the trust. That's in life and in death. But this doesn't have to go through the court process, so you're on your own time, not the court's time. And so even though the minimum amount of time, if everything's going smoothly and everybody's on one accord, is about 8 months for probate, because you got to do all those publications and all that kind of stuff. But the average is about 1.5 years. If you're a resident of Fulton County, it can take like years, because right now they're having a lot of administrative issues. Okay, they have a lot of turnover. We go up there, Jason goes up to the court every month. We call regularly to follow up on things that should have been finished 1 year ago, 2 years ago. But that's the trust. That's the revocable living trust. Most of those principles are similar for the irrevocable trust. I do have a comparison of the two on YouTube of the Medicaid Asset Protection Trust. There's lots of different trusts. We talked about the benefits of the trust to provide management of assets if you become incapacitated, to avoid probate, protect your family's inheritance, and to promote family harmony. I have a big family, so I have lots of examples. I'm the oldest of 7, and so we're all very close, but we're all very strong personalities, and we were raised to be in charge. And so if my dad had not said who was in charge when he did his planning, that's where the fight would have been. Okay, everybody would have been raising their hand to be in charge because they're the best qualified. And when we were at Murray Brothers, Mr. Murray said, I am amazed at how well y'all handled that. He's like, I've seen some things around this table. We voted, but there were 2 people, my brother and I, who were in charge. And even when I said, well, me and Ollie can decide, everybody's like, no. And we backed down. So, but some families aren't like that. So, promote family harmony. These are the things we talked about. Plan, avoid probate, protect against spousal remarriage, blended family issues. The other side of that, the other aspect, is maintaining your plan. We know life changes, the laws change, and we get new techniques. Like one example is the estate tax exemption. So there's different types of taxes: capital gains, income tax, estate tax. estate tax is on transfers after your death. Well, once upon a time it was 100,000, then it was 600,000. You know, a house could take you there now. And then with Obama, it went to 5. With Trump 1, it went to 10, and it gets adjusted for inflation. With the big, beautiful bill, it went to 15. Okay, so if an individual has $15 million worth of assets, they don't have an estate tax unless they have over $15 million of assets. And for a married couple, you have to have twice that. And even at the $5 million threshold, 99% of Americans did not have taxable estates. So that's not a real big concern for most people. There are some people. But that also was a big source of money for the government. And so if the government runs out of money, they may take that exemption down. So you always have to review your plan in light of changes in life. You know, an agent may not be a good age. Maybe they have dementia, or maybe they died. Maybe you get divorced. Maybe you get married. Maybe you have a child. So you got to look and see if your plan still does what you need it to. I have probated wills that were, one will in particular was created in Michigan in the 80s. This person has died. He had a copy of the will. You have to probate the original. The lawyer was dead. The witnesses, one was dead. The other had been remarried. We had to get a private investigator. We were able to find him, and she was a senior citizen, so when I called the husband, fortunately, he was an estate attorney, so he knew what I was doing. But, you know, people, you know, there's a lot of fraud going on. So you want to make sure you're maintaining that. Don't know what just happened there. Okay. So, incapacity planning. So we talked about the trust as one tool. The other tools are the, you've heard of financial powers of attorney, healthcare powers of attorney, and living wills. In Georgia, we have a statutory advance directive for healthcare that combines the healthcare power of attorney and the advance directive or living will. So the healthcare power of attorney is where you designate agents to make decisions for you if you cannot communicate about your care, if you don't have the mental capacity to be able to communicate those for yourself. And so that you want to choose somebody who understands what you want and would comply with that. The living will is not a will. It's your instructions on what you want done if you're in an end-stage condition. So if you have a terminal condition, maybe you're on life support, and 2 doctors say, we're treating you and it's keeping you alive, but we can't make you better. Okay? So, and if we disconnect you or stop treating you, you'll probably die pretty quickly. What do you want us to do? So the living will, or the advance directive, is where you are able to say, keep treating me, pull out all the stops, or allow me to die naturally, but give me pain medication, or something in between. Give me a ventilator. People used to say no ventilator, and then COVID happened, and the ventilator was helping. Feeding tubes, nutrition tubes. So you get to say. You also get to determine, you know, when you do your planning, how it's determined that you're incapacitated. Do you want a panel of people? Now I'm talking about your finances. Do you want 2 physicians? Well, how do you want that determined? Your spouse? Who do you want to make that determination? Okay, so the financial power of attorney, that gives an agent that you designate the authority over your property. Property that you own. So if it's in a trust, the agent does not have authority over it unless they are also the trustee. Okay, so powers of attorney can be limited, or general. General is it's over everything. Limited, it can be limited in time. So maybe you're going out of the country, or you're going to be deployed, and you want somebody to manage things while you're gone. Another example I like to use is my sister and her husband. When they bought their first house, they weren't going to be in town for the closing. So they gave my mother power of attorney for that limited transaction. And she signed at the closing, and then she had no more power after that. Okay, so that's limited by transaction. Limited by time is like when you're going out of town or whatever. You can designate the period. And then general, the word durable means, because you have to have mental capacity when you create any of these tools. And so durable means if you become incapacitated, it's still in place. So that's the durable power of attorney. General means it covers everything. Limited is limited in time or transaction. And then springing, if it's effective immediately, as soon as you sign the paper, the power of attorney, whether you have incapacity or not, they can go to the bank and sign your checks. And I had a client whose child did that. They co-signed her name to the grandchild's student loan. So you have to, when you're selecting your agents, a lot of people come in and say, I want to make the agent the oldest in charge, and they'll do the right thing. But if you leave it to the oldest, you know, when you die and it goes to them, like if you make them the beneficiary of the insurance, then when they get that money, it's theirs. What if they're having hard times? What if they're getting divorced? Well, you know, maybe they mean well, and they'll do it the next, when things get better, but that money's gone. You know, what if they feel like I took care of mom, I should get this money or I should get more of it. So you have to plan the way you want it to go. You have to designate who you want to have it. And don't leave somebody else to make that decision for you. We talked about the power of attorney, the HIPAA release. You know how you go to the doctor and the doctor gives you their privacy statement. That says that they can't give out your confidential medical information without your written permission. So the HIPAA release provides a list of people who can get that information. It doesn't give them any power other than to talk to the doctors. The Advanced Directive for Healthcare, that the agent has no power unless you are able to make decisions for yourself. The financial power of attorney, it's effective upon signing if you make it effective immediate. You can make it springing, meaning it doesn't become effective until a certain event occurs. So you can say it's only effective if I'm incapacitated, and this is how my incapacity is determined. All right, we've got 2 minutes. And I think we have covered everything. So the biggest thing is you need to plan now, okay, if you haven't planned. Because, you know, like I talked about the young man, he wasn't 30, 40, 50. He was in an accident with that drunk driver driving in the wrong lane on the highway. Or you get people like my dad. He was never in an accident, but when we realized there was a problem, he was telling me, I was on the highway and everybody was driving in the wrong direction. So who was driving in the wrong direction? Okay, so things like that happen. So, are there questions? Yes, sir. How much does it cost to set up a trust? Okay, for the most part, for me, you can plan on 4 figures. For trust planning, it's going to depend on the nature of your estate, but for most people, I charge $5,000 and half off for the second spouse, which leads me to spouses can plan with the same attorney, but you both need to meet with the attorney at the same time. How many people in here are married or have been married? Did you agree on everything all the time? Okay, so there are inherent conflicts of interest. You may not want to do the same thing. And so when you meet with your attorney, they're supposed to explain to you that you can have separate attorneys. But if you choose to work with the same attorney, you have to waive those conflicts of interest because there's no secrets between the attorney and the two of you. One of you can't call the next day or the next week and say, I want to make this change, but don't tell my spouse. Then the attorney has to say, you need separate attorneys if your attorney's ethical. And that conversation needs to be had at the beginning of the engagement so you can make an informed decision. Okay, and so because you can plan separately. Did I answer your question? Yes. Yes, ma'am. Okay, so her question is kind of a family law question, marital property. And family law rules are different from probate rules. Okay, so with and I'm not a family law attorney. I was for maybe a year, many moons ago in Maryland, and it's different from state to state, but family law, marital property is property acquired during the marriage. So even if it's a homemaker breadwinner, the income belongs to both of them. So everything that comes in, the savings, even if one person is not working and they're not bringing in the money that comes into the marriage is marital property. And so it's subject to division when you get divorced. Inherited property is not marital property. But if you have a house and you renovate it or you fix it, you're spending marital property, the money that came in during the marriage, to fix up this house. So that muddies the waters, and that makes it subject to that argument during divorce. And so that's why, in a divorce, like when we talk about protecting for your children, you know, your child is married to somebody who you think is a deadbeat or whatever, you leave something to them, you leave it in trust, the divorcing spouse is a creditor. But if you put that trust protections on there, then you can protect it for them because you've put it in trust and you said it can't be used to pay the creditors. And then it also depends on the language, because we talked about health, education, and maintenance. That's a tax term, and it's actually HEMS, health, education, maintenance, and support. You can use any of them. We've stopped using the term support because there are some states that have used that support to reach into the inherited property that's in the trust to support the divorcing spouse. Support and maintenance are basically the same, and as of today, there's no state that has a case where they've reached into maintenance standard to get to that. That doesn't mean that next year they won't, but that's the way it works right now. So that's the other thing, is that when you're selecting an estate planning attorney, you generally do not want a general practitioner. You want somebody who focuses in the area of wills, trusts, and estates, and keeps up with the law. Anybody else? This is the last session, right? So are they coming in here after? Okay, so we got questions until we get kicked out. So, no questions? Well, I am going to, if you sign up for my newsletter, my business card has my QR code on it. And where's the question? Yes, sir. Do I go to a site? Yes, we do charge extra for that trip charge, but we do Zoom as well. Yep. And so, and let's talk about Zoom, okay? Because so a lot of times family members come with the person who's planning, and particularly adult children with their parents. So the person whose planning has to have capacity, and they're the ones who make the plan. So I get adult children all the time who say, I want to make a power of attorney for my mother. You can't do that. Only your mother can make the power of attorney. It does not matter who is paying for it. The client is the mother, okay? If you go with your mother to the meeting with the attorney should make you wait in the waiting room, because the attorney has to determine whether you have the capacity to plan. We have to make sure there's no undue influence and that you're doing what you want to do. Okay, I had a charming, and with Zoom, you know, people stay in the room over there, but usually you can see the person looking over there, you know, and that kind of stuff. And so, but I had this charming man who was retired, he had dementia, and my dad did his planning when he had Alzheimer's. If you have, it's called moments of lucidity. So as long as you know at the time you're planning and at the time you're signing. And so, but this man, I knew he was retired. I knew his kids were helping him pay the bills. And it was the middle of the day, and I was like, so, Mr. Smith, do you work? And he's like, yeah, I work. I said, what time do you work? He's like, 9 to 5. And it was 2 o'clock. Didn't mean he couldn't be taken off. I said, well, what do you do? He said, I work. I said, well, where do you work? I said, I work where I go to work. I said, but if you were just talking to him and not asking him those questions, you would not know he had a problem. I asked him, do you pay your bills? Yes, I pay my bills every day. I said, what kind of bills do you pay? Who pays the bills for you? I pay my bills. What bills do you pay? I pay the bills that need to be paid. So I won't touch his plan. Okay, but I think we're done. I see a whole bunch of people coming in now. But thank you. I think this is year 5 for me, and I appreciate that you guys invite me back. I was going to say, too, with my card, there's a QR code, and I am going to be doing seminars, and they're free, but like at the end of the month, the 24th and the 26th, there'll be seminars at the Holiday Inn Express near the airport. But if you can, there'll be information in the newsletter.
Brothers and sisters, we're going to wait until just a few more people coming in. Some people are trying to make sure that they know how to be millionaires before they come back. So we're working on that right now, but they will be here very, very soon. What I would invite you to do right now, if you went to a class different from someone who is around you, what I want you to do is to communicate to someone who is near you who went to different, find out what classes they went to, and then share with somebody who went to a different class. I want you to share with each other while we're waiting for everybody else to come in. Let's do that right now. Find somebody who went to different classes. Find somebody who went to different classes and share with them right now.